Welcome to the Legal Services Alabama video series of helpful legal information for older adults. Today we will talk about guardianships and conservatorships. We will learn how to help older adults stay independent and avoid or end guardianships and conservatorships. We all want to be independent and make our own decisions about where we live, healthcare, and our money. Getting older does not necessarily mean that we're no longer able to make decisions. Sometimes family members or others think that they know what's best for an older adult. They may file papers to get guardianship or conservatorship over an older adult. Sometimes this is necessary, but often it is not. We're going to talk about what guardianships and conservatorships are, when they're needed, and how to get help if they go too far and need to be stopped or changed. What is guardianship? A guardianship is created when a probate judge appoints someone to manage decisions about a person's health care and living situation after the judge finds that the person cannot make those decisions on their own. In Alabama, a guardianship can only be created by a probate court. The process starts when someone files paperwork with the probate court saying that someone needs to be appointed to protect and care for an incapacitated older adult. We will explain what incapacitated means under Alabama law in just a minute. If the probate judge finds that the older adult is incapacitated and cannot make responsible decisions on their own, the judge can choose someone to serve as their decision maker and caretaker. That person is called a guardian. Guardians have a lot of power, so guardianship should always be a last resort. So, what does incapacitated mean here? Alabama law says incapacity is when someone has one or more of the following: mental illness, mental deficiency, physical illness or disability, physical or mental infirmities due to advanced age, chronic use of drugs, or chronic intoxication. So remember, to get guardianship over someone, they must be incapacitated under Alabama law and unable to make responsible decisions on their own. Older adults don't have to make perfect decisions all the time, but they must be able to make responsible decisions. What is a conservatorship? A conservatorship is created when a probate court appoints someone to manage the money and property of another person who's incapacitated and unable to handle these matters. The person chosen to oversee the money and property is called a conservator. This is a lot like guardianship, except that instead of managing healthcare and living situations, a conservator manages the money and property of the protected person. Like guardianship, the process starts when someone files papers in court asking for a conservator to be appointed. Also, like guardians, conservators are only appointed when a person is incapacitated and cannot make responsible decisions on their own. Conservators, like guardians, are usually given a lot of power. So again, this should be a last resort option. How long do guardianships and conservatorships last? If an older adult recovers from whatever was causing them to be incapacitated, so they are no longer incapacitated, the guardianship or conservatorship should end. A guardianship or conservatorship will not end automatically, however. Someone must file papers with the probate court asking to end it and explain why it's no longer needed. If that happens, the probate judge will decide whether the guardianship or conservatorship will end. If no one ever files papers to try to end guardianship or conservatorship, they can last for the life of the protected person. How can guardianship and conservatorship powers be limited? Remember that any powers a judge gives to a guardian are powers taken away from the protected person. If someone files for guardianship or conservatorship on you or someone you know, ask first, is the person truly incapacitated under Alabama law? Also, there must be a real need for someone else to make decisions. If both are not the case, it may be best to find a lawyer to fight guardianship or conservatorship. If guardianship or conservatorship can't be avoided, the judge should still leave as much power as possible with the protected person. For example, a temporary guardianship or conservatorship might be enough to protect the person if the incapacity is only for a limited time. Suppose the person doesn't need help with healthcare decisions now, but wants someone to make healthcare decisions for them later. In that case, other good options are power of attorney, advance directive for healthcare, and living will documents. In Alabama, advance directives for healthcare will most likely have a living will section. Maybe the person only needs direct deposits to be set up, or maybe automatic payments to manage their money if the issue is they can't get to the bank. Maybe getting a Social Security representative payee or a VA fiduciary is all that's needed. If the person doesn't need help managing money now, but may in the future, a financial power of attorney is likely a better option. Why should guardianships and conservatorships always be a last resort? There are many reasons. First, to get guardianship or conservatorship, we must go through the court system, which is very complicated, time-consuming, and may be expensive. There's a fee to file these papers, and a bond must be posted. In Alabama, the bond is often thousands of dollars. Remember, too, that guardianship or conservatorship will continue until someone files papers and a judge rules to stop them, and this can take some time and effort. There are often much easier ways to achieve the same goals that let older adults keep more decision-making power for themselves. Also, the judge has the power to choose the guardian or conservator in these cases. The person that the judge picks may not be someone you would have picked. If you have a power of attorney document, however, you name who has the power to do or decide things. Again, guardianships and conservatorships should be a last resort option. Older adults should make their own decisions unless they get to a point where they cannot make decisions on their own. What options are there other than guardianship or conservatorship? We can take charge and plan for our future by making other documents to protect us. Power of attorney, advance directive for healthcare, and living will documents are good options to consider. These documents let you choose who will handle things if you reach a point where you can't do it yourself. These documents can be as broad or as limited as you want them to be. They can be done without going to court, and you don't have to have an attorney to do them, although you should try to get help from an attorney if you can. For more information about these documents, check out the Legal Services Alabama Planning for the Future video in this series. We have the power now to plan for our future. If you need help stopping, limiting, or ending a guardianship or conservatorship, contact Legal Services Alabama for help. You can call the Legal Services Alabama Elder Helpline at 866-456-3959. Please keep in mind that we do not help people file to get guardianship or conservatorship. For more information about our free legal services for older adults and to read our legal guidebook for older adults in Alabama, check out our website. We hope you will watch all of the videos in this series that were created to empower you to take control of your life, your finances, and your independence.